Looks like our participants are starting to level out a bit, so I think now is a good time to get started. So, yeah, welcome everyone. Thanks so much for joining us here today. I'm super excited to hopefully maybe clarify some really confusing things about NCAA athletics that we have found ourselves in this world today. For those who don't know me, I'm Mike Babich. I'm a senior recruiting analyst at SportsRecruits, mainly focusing on assisting people in the recruiting process. And a big part of that is trying to make sense of a lot of these major changes that we've seen within the NCAA over the last few years. There has been some significant confusion, so I couldn't think of anyone better than to bring on than Sam Ehrlich here. And Sam, I'm going to give you a chance just to give a quick introduction of yourself, if you don't mind.
Absolutely. Yeah. My name is Sam Ehrlich. I am an assistant professor at Boise State University in the Department of Management. So both of those names are about to change because I'm about to get tenure and
That's
I'll be switching departments. So need to change that script in my head a little bit pretty soon. But yeah, my research interest has been in the legal aspects of sports and the legal aspects specifically of college sports. And really all of my research is surrounding kind of all the changes that have happened in college sports over the past 5 years, since we started doing NIL and we had the Austin Supreme Court case and all these different things that have really led to, largely speaking, a breakdown of the NCAA's legal defenses in this area. And as part of that work, I run a website called the collegesportslitigationtracker.com. It was really something that was started for my own personal benefit, just to try to keep track of everything and have one place to do it. And apparently other people were looking for something like that as well. So I love the fact that people have found it useful. But yeah, it's kind of funny. Mike mentioned out these eligibility issues. I started the tracker before we had all these eligibility cases, and definitely has
yeah.
made that job a lot more difficult, but a lot more fun because there's been a lot of these lawsuits. 40 in total at this point, that challenging the NCAA's eligibility rules. And that's taken up a lot of my time, but a lot of my interest as well, because they're all fascinating issues.
Yeah, and Sam has been an incredible resource for sports recruits. He's kind of been someone that we've looked at, particularly over the last year and a half, in regards to the NCAA House settlement. So, any article or any social media post that you saw us put together, chances are Sam was going to be the person that was kind of verifying a lot of that information. I did put his link to his X account in the chat. So if anyone is interested in seeing that tracker, and he's always really up to date on any major changes in any lawsuits that may get completed, or if there's anything that is ongoing that's interesting. So definitely make sure to follow him there if you are interested in this topic for sure. But I figured, Sam, and we want to give everyone a chance to definitely ask questions on there, but there are definitely a few things I wanted to cover first. If anyone does have questions about NCAA rules, regulations, if you're unsure of how these different things work, feel free to use the Q&A box, and we'll definitely have some time at the end to go through those. But I just have a couple of things that I wanted to ask Sam about here to get started. So I think a good place to start is actually based on a conversation we had previously, which is really in regards to this NCAA House settlement. And for those who aren't aware, basically this is the first year that we have gone into the revenue share era of college athletics, where Division I student athletes have the opportunity to get paid directly by their college program. As Sam mentioned, NIL has been around for a few years at this point, so people have been able to make branding and marketing deals. So it's not necessarily the first time student athletes are making money. It's specifically the first time colleges are paying their athletes directly. So in those first few months, I believe end of June, start of July was kind of the technical start of this rev share era. What have you noticed, Sam, so far in terms of any major changes or any interesting tidbits that you've kind of come up on now that we are in this new world of NCAA D1 sports?
Yeah, I mean, you hit the nail on the head. I mean, the House settlement does a number of different things, but you can really think about it overall as the NCAA's attempt to legitimize NIL, to try to, cut down on what they see as kind of fake NIL, kind of, using NIL as kind of a backdoor and end around, through NIL collectives and through boosters to really have just pay for play without any real consideration on the other end, where the athlete's actually performing a endorsement or sponsorship or some kind of other service in exchange for that NIL money beyond just, being on a particular team and playing and playing for that particular team. And the House settlement really does, what it does is it allows colleges to play, just like Mike said, it allows colleges to pay athletes directly up to $20.5 million. It, has the roster limit caps, which have definitely been a source of contention, but they are there. And it also has the NIL Go system, or what's become the NIL Go system, set up by the new College Sports Commission, which was founded about 15 minutes after the House Senate was approved on June 6th. And NIL Go is kind of the clearinghouse for NIL deals for, that give the College Sports Commission in their, through their charge based on the House Settlement, the opportunity to review them to determine whether they are of fair market value, or I guess they don't like the term fair market value anymore, of a reasonable range of compensation is how they frame it now, and whether they are for a legitimate business purpose. And there's been some bumps in the road, definitely, in regards to the NIL Go system, in regards to kind of the College Sports Commission's role in kind of in really enforcing the House on its terms. There's a little bit where it was really unclear whether collectives were just going to be kind of eliminated en masse from being able to show they were kind of had any kind of legitimate business purpose. The CSC has backed off from that, at least for now. And also just really, there's been a lot of complaints about kind of the speed of the NIL process. That's been a thing. Originally they were apparently going to do it through algorithms, but they since backed off of that, probably fearing some kind of legal challenges to that. And I think even more than that, just looking at the analogous system, and I think this is, for our conversation, for, talking about recruiting, this is a big source of contention as well, where the NCAA feels that the NCAA and the CSC feel that they can require high school athletes to submit their deals as well through NIL Go prior to being a college athlete, even though the House settlement really doesn't give them the power to do that. But that's still being worked out. And I think in a lot of ways, NIL Go, it's really kind of we're waiting to see a legal challenge to it, and it's coming. There's going to be a legal challenge to that. I haven't seen any rejected deals, which might be part of it, but apparently there have been some, just based on the numbers that they've given out publicly. But I really do think eventually we are going to see some legal challenges, and that's really going to show us how sustainable that model is, how sustainable the College Sports Commission in general is, and whether really it has any teeth. Because, yes, there's been rejected deals. I haven't seen any athletes get punished, any schools get punished, and that's where things are really going to get tricky.
Yeah, and I think I'm so glad you brought up that piece of it, where there are student athletes now who are currently in high school who hypothetically might be able to put together some sort of NIL marketing deal or promotion where they're able to earn financial compensation. Since we have current club directors and recruiting coordinators who are watching this right now, they may be getting approached by their student athletes that they work with about, hey, what should I do about this? Like, should I keep track of what's happening? What would be your advice to someone who works with current high school athletes who seem to be on that track of becoming a Division I athlete? What's the best way that they can set themselves up for success to make sure that they won't be putting themselves at risk with any sort of eligibility issues down the road?
Yeah, I think practically speaking, and this isn't even a statement on the legality or lack thereof, or however I feel about NIL in general, or the College Sports Commission in general, but practically, I think it's always wise to keep track of every NIL deal that you do as a high school athlete, as any kind of athlete, as any one period. Just have a record of it, not only for amateurism purposes, or quote unquote amateurism purposes. I don't know how much we can call Division I sports amateur anymore, but not only for those purposes, but also for tax purposes, for
Yeah.
um, anything like that. Like it's just smart to keep track of those records and truly have them and be able to rely on them in case there are questions, either from the NCAA or the College Sports Commission or the IRS. I mean, it's just kind of important to have those records, and I think more so, even if we were to assume that NIL Go is not sustainable, that or even kind of to a lesser extent that the College Sports Commission can't require high school athletes to submit deals to NIL Go. For one, we don't know that, and for two, that's not going to happen. Like that wouldn't be challenged until there's actually a legal challenge. Which, if the CSC decides to stick their heels in, that could take months to actually kind of weigh out. And by that point, an athlete may have lost significant time to their eligibility. So I definitely think it's important to at least pay attention to the rules and kind of know what's going on, and be willing to or at least keep track of the information so that you can use it to defend yourself if need be.
So if let's say you're hypothetically, you're a current high school senior and you are someone who did have an opportunity to create some sort of NIL deal for yourself.
Mhm.
As it stands right now, the College Sports Commission, the CSC, as you refer to them, right now the rule is prior to you starting courses at your college, if you commit to a Division I school, that would be the time where you would need to release that particular information about that NIL deal. And for high school athletes, is it in that value of $600 or more? Is it that same rule for high school athletes as it is for college athletes right now?
That is my understanding, yes.
All right, great. Good to know. Yeah, I think that's something. I'm not sure how much high school NIL is currently happening. Of course, we see the big news stories when it comes to the college side, but I do think it was important for us to at least make a note of it because it is something that did come out relatively recently that they are trying to encourage high school athletes to really report that information. And to your point, they're not really even part of the house settlement, which was kind of
Yeah.
interesting. So, one thing that we try and recommend to anyone who utilizes sports recruits, any club director that we work with is look, it's definitely exciting to have these opportunities for financial advancement. There's really never been a time where you have been able to generate revenue for yourself more than you could right now as a collegiate student athlete. But we really try and recommend best fit. So yes, of course, the financial piece is going to play a factor for that for many future college athletes across the country. But we wouldn't want necessarily recommend, hey, go to the place that's offering you the most money or go to the place that's providing you with the best scholarships. Would you echo that on your end? And what are some of the things, maybe in your experience working at Boise State, what are some of the things that you look for when you're meeting with, student athletes or current students when they're trying to find a school that makes the most sense for them?
Yeah, well, I mean, in my role, I don't do a whole lot of that,
Sure.
but whenever I'm asked, and whenever I'm asked, I completely agree with you. I think that finding that best fit, finding kind of the more holistic fit, is better than just looking for the biggest paycheck. And especially since I think for a lot of athletes, getting the biggest paycheck, especially as a freshman, means that you're going to be sitting on the bench, and maybe you have a chance to develop, maybe you have a chance to get significant reps and practice, but you're probably sitting behind someone because the schools with the biggest amount of money also have the established rosters, and there's also a bigger risk that they're going to go into the transfer portal to find someone who's better than that player. So I think finding a school that has a coaching staff where you trust, or where the athlete trusts them, and finding a school where they just like the vibes of it, that's going to be a lot more important because I mean, at the end of the day, there's also always a risk of, unfortunately, injuries can be a thing, and you're going to want to get the degree that you want to get, and that's still a big part of college sports. That's not going away, even with, a paycheck on the side.
Yeah, you see all these articles and you see all this media attention. You really don't hear too much about the education for a student athlete in the world today, which I think is obviously kind of missing the mark almost at sometimes. But I think this is a perfect segue to kind of go into because Division I gets so much attention. I think it is important to really reflect and focus on what a majority of collegiate student athletes are, which is outside of Division I. So whether that be Division II athletes, Division III athletes, but even outside of the NCAA, we have a lot of student athletes who use our site who end up going to junior college programs and NAIA programs, for example. One thing that we get constant questions about, because I think it's really difficult for someone who may not have a ton of training in NCAA rules and regulations, is how exactly eligibility works for someone who decides to go that non-traditional route of an NCAA sport. Would you be able to give us an understanding of a current high school athlete? They're a junior, they're a senior, they're looking to try and, significantly increase their chances of playing D1, and they're looking to go to NAIA or junior college route. How is their eligibility affected by that path as it stands right now?
Yeah, and I think this is a major source of a major question right now and a major source of confusion. And I'll explain, why there's so much confusion in case,
Yeah.
people aren't familiar with it, and also, kind of where, where the future might look. Because at the end of the day, the current NCAA rules, and I'm stressing current
Yeah.
because we'll get into why, but I'm stressing current. The current NCAA rule is that you have 4 seasons in 5 years. You have 4 seasons to play and 5 years of eligibility, a 5-year clock. That could be mitigated in some ways by things like, well, COVID years aren't going to be a thing anymore. Hopefully not. But things like, injury hardship waivers, stuff like that.
Mhm.
All that gets a little complex, but the general rule is 4 seasons in 5 years. And
Yeah.
as it pertains to non-NCAA schools, so JUCOs, NAIA, NJCAA, all those different acronyms, the NCAA considers under their rules any intercollegiate competition, which includes junior colleges, NAIA, etc., to count those years to count towards your your 5-year clock and your 4 seasons clock. And the 5-year clock starts when you first enroll at an institution, or even really, after you enter high school or after you graduate high school. That kind of depends on a few different factors. But the easiest way to say it is when you start college, your 5-year clock starts, and every season of intercollegiate competition, which includes, again, JUCO, NAIA, etc., counts towards those 4 seasons of competition. Now, I said current rules. And that's because there's been a lot of legal challenges over those rules. The most famous, of course, was the first one, Diego Pavia, the quarterback at Vanderbilt, who was able to file a lawsuit and get a preliminary injunction that allowed him to play an extra year because he was able to argue that, based on antitrust law, that his junior college year should not count towards his 4 seasons of eligibility. That it was a deterrent against going to junior college. It was a restraint on competition between the NCAA and junior college. Those kind of things. We won't get into the weeds, but that's kind of what you need to know. And since then, there's been 39 other lawsuits, 40 in total, that have attacked a lot of different areas of kind of the NCAA eligibility scheme, but a lot of them have focused on that same junior college argument, saying that junior college year should not count. And a lot of courts have granted injunctions. They've said, we're not going to count this. We agree with you. We're not going. This doesn't make any sense to count it the same as a Division I year. We're not going to count towards that, and we're going to give you this extra year of eligibility. I think there's been roughly 10 to 12 players total that have gotten injunctions, and possibly more to come.
Right. So just to try and, I guess, really simplify this for people, because I think there's another piece of this as well, where I think the point that you really drove home that makes the most sense to me is intercollegiate competition. Because I think there also is another route for student athletes where they consider going the preparatory school route, where that is hypothetically a way where you graduate high school, you move on to a prep school. Your competition at a prep school would not count and start your eligibility clock. If you are someone who goes from high school to an NJCAA, a junior college program, or an NAIA program, as it stands right now, that does start your eligibility clock. The situations that you're referring to are people who are current collegiate athletes who earned an additional year of eligibility because they went through the lawsuit process, basically arguing you are minimizing my opportunity to earn NIL revenue. Is that a good way to simplify it?
It is. It's 100% accurate, and I think it is really important to stress that, because I get asked by athletes all the time. I get questions from athletes all the time, through Twitter DMs or emails or things like that, saying, "Well, since Pavia got his extra year of eligibility, does that mean I get one as well?" And the answer is no, at least not yet, because the NCAA hasn't changed its rules. Pavia and these other players were able to get preliminary injunctions for themselves,
Yeah.
and this is changing, but their lawsuits only impacted themselves. They did not give kind of broad relief across all of Division One. They did not force the NCAA to change its rules. The NCAA rules are still the NCAA rules. And in order to get this extra year at this point, you have to file a lawsuit and win that lawsuit.
Right. So as of right now, I believe I also saw something relatively recently where the NCAA came out and said they will not be making a change to that 5-year clock in terms of
Right.
what's going into next year. So
Yeah.
fair to assume at this point, if you're a current high school athlete and you're going towards that JUCO or NAIA route to try and extend your NCAA Division I eligibility, as it stands right now, that would not be doing any extension, but it could change in the future.
Yeah, that proposal wasn't even related to JUCO or NAIA. That was
Yeah.
related to there's been a lot of talk, there's been a lot of proposals surrounding, instead of having 4 seasons in 5 years, where you could have a redshirt year and sit out for a year and be able to have that full 5-year clock. You could just play five seasons in 5 years. There's no more redshirt year. It's just you have 5 seasons, or you have 5 years, 5 seasons. That's all. But the NCAA has put that proposal on hold
Right.
due to all this litigation. They want to make sure they don't. It gets a little complicated, but the short answer is they don't want to kind of take away their chances from their chances of having a court say first that they are allowed to make these rules. They don't want to kind of see that argument and not be able to defend themselves in court as easily.
And I think also if you get to this situation where again, it would be great to have that ability to give people more eligibility, but the more that you do that, the less likelihood there is for a high school athlete to break through too.
Yeah.
because if you have more people taking advantage of, again, this is not the rule now, but if you have people who are going that junior college or NAI route just to play collegiate level competition, but not count towards your eligibility clock, that's going to make it only more difficult to break through to the Division I level as well.
Yeah, that's been a huge part of the NCAA's defense in these lawsuits. Every single lawsuit they've brought up the fact that, just in terms of pro-competitive benefits, the idea that these rules are good, that they should be sustained, is the fact that it does allow for kind of a greater flow of talent through the college system.
Yeah. And again, I know that's been kind of like a major driving point for a lot of people that we work with directly. So again, if anyone does have any follow-ups on that, or if there's anything that you are experiencing with the current student athlete that you work with now in regards to NIL or eligibility, again, feel free to utilize that Q&A box, and me and Sam will do our best to try and formulate the best possible answer for you on that topic. One other thing that I wanted to make a note of too here as well is because something that I've seen get a ton of attention, see a ton of commercials for it when I'm watching college football on the weekends, is it looks like there's these two different acts that the NCAA is looking to potentially utilize, I guess, to would it be the best way to explain it? I guess to federally put college athletics under the same umbrella. The two acts that I see are the SCORE Act and the SAFE Act. For those who may not have even heard of what those are, would you mind giving a quick recap of what these acts are and what their ultimate goals are, and maybe the differences between the two of them?
Yeah, so both the SCORE Act and the SAFE Act are really intended to um, really find a way to nationalize rules across college sports. There's been a lot of NCAA lobbying. There's been a lot of NCAA statements about we need to kind of safeguard these rules. We need to have consistent rules that are not changing both on a state by state level, because right now right now NIL is controlled exclusively at the state level, and the state laws do vary at least in a little to a certain degree. Um, but also they want to ensure they want to have an exemption from all these lawsuits, an antitrust exemption that allows them to make rules like eligibility rules and have those rules not be challenged or not be able to be challenged under federal antitrust law, and lose a lot of these lawsuits. The NCAA right now just has a lot of issues with kind of being able to control the sport, being able to kind of have the power to do so without getting sued. And they see the SCORE Act. I won't throw the SAFE Act into there because the SAFE Act is a very different bill, but the SCORE Act is definitely their way of getting this done. And the big difference between the SCORE Act and the SAFE Act is one is a Republican bill, the other is a Democrat bill. And the SCORE Act, kind of the one that has the most legs at this point, mostly because we have a Republican Congress, is that it would really just give a lot of power to the NCAA. It would give them their antitrust exemption. It would declare that college athletes are not employees. It would do all the things that the NCAA wants Congress to do. The problem is, for one, I don't think it's constitutional. I recently wrote an article about that, but that gets way into the weeds. We won't touch on that. And that's also my harebrained theory. Who knows if that's actually the truth? But two, yes, we have a Republican Congress, but we have a requirement in the Senate where you need 60 votes, and Democrats have really come out strongly against the SCORE Act for a variety of different reasons. They say it's anti-labor, it's anti-athlete, and it does seem like even if it passes the House, which it looks like it's going to get a full House vote in the coming weeks, potentially, I think it'd be very difficult for it to pass the Senate. So yes, it's a proposal right now. It would give the NCAA a lot of power, and really do a lot to codify these eligibility rules. But whether it actually passes or not, I think is questionable. The SAFE Act, on the other hand, it's a different proposal. It's very much focused towards health and safety. It's very much focused towards requiring schools to do a lot more for their athletes. It does not have any kind of employment exemption. It doesn't have any antitrust exemption. It does do some things to codify some of these rules, but mostly kind of really puts the NCAA in a lot of ways under the umbrella of the federal government, to where they can kind of dictate certain things as well. Including, one of the big things here is, you may have seen some of these commercials from Texas Tech booster and regent and billionaire Cody Campbell. He wants to amend the Sports Broadcasting Act, which, very generally speaking, what it would do and what the SAFE Act does through this, because the SAFE Act really carries through that proposal into it. It would It would allow for revenue sharing across all divisions, or not across all divisions, but across all of Division One. So you wouldn't have the same kind of situation where Big Ten schools get, about $70 million per school, based on what I last saw, and Mountain West schools only get about $7 or $8 million per school, just in terms of media rights, or at least that's the proposal. Obviously, that one, the Big Ten and the SEC are not particularly thrilled about it.
Yeah.
They are not, they're very much not on board. And it being a Democrat proposal, in this current Congress, there's not much of a chance of that either. So that's one that I haven't really been paying as much attention to.
One follow-up I have to you, I guess more so in regards to the SCORE Act, athletes becoming employees. That's just something that I think I have trouble understanding because you are someone getting paid by your university that you attend, but there seems to be this holdup on classifying them as an employee, and I guess it kind of makes them look more of like an independent contractor. And feel free to correct me if that's the case. Why aren't athletes considered employees, and why would the NCAA in particular not want athletes identified as employees?
Well, the answer to your first question, why they're not considered employees, is because the law just hasn't gotten there yet.
Yeah.
We have a case that's going on in Pennsylvania right now, Johnson v. NCAA, involving a former Villanova wide receiver football player. It's a class action lawsuit, so it's not just him, but he's the Johnson v. NCAA. Back in July of 2024, that actually went to the Third Circuit Court of Appeals. The Third Circuit Court of Appeals said, yes, we are affirming the idea that the NCAA's motion to dismiss this lawsuit is, we're denying that. We're affirming the lower court's opinion on that and saying, yes, it is plausible for a college athlete to be considered an employee. They gave a test to determine kind of which athletes should be considered employees and which athletes shouldn't. They want to draw a line between athletes who really are there simply for an extracurricular activity, and they're not there to, in a way that kind of more benefits the school more than it benefits themselves. That's a very oversimplified kind of version of what this new test is, but it's very much focused towards what benefits do the athletes provide the school, and do those benefits outweigh the benefits that they get from playing intercollegiate sports. And trying to figure out that line is going to be difficult. It's going to take many years for it to do so, but the NCAA is terrified. They really, really, really do not want college athletes to be considered employees, because there's just a gamut of federal laws that would apply to college athletes if they were considered employees. Things like workers' compensation, which the NCAA has fought against for decades. Things like minimum wage, where yes, a lot of athletes through revenue sharing now are getting paid more than minimum wage, and potentially even for other athletes, you can maybe make an argument that I've written an article about this, but you can maybe make an argument that college scholarships can count towards minimum wage.
Right.
But there's still a lot of unanswered questions there, and a lot that would have to be worked out through there. And also things like healthcare and all these other employment benefits that,
Sure.
for one, are it's just a very large box that has yet to be opened. And for two, it varies significantly on a state by state level. So it's just something the NCAA does not want to deal with, because it would really, really hurt their business model.
Okay, that definitely makes sense. And I think the last thing that I'll ask before, it looks like we have one or two questions that came in so far, and I'll give everyone an opportunity to continue to put their questions in the Q&A. If you were, for the recruiting directors, for the club directors that are with us right now, and they are looking to be the person who stays on top of these potential major changes, or they want to be able to be that asset to a student athlete who doesn't know what these recruiting rules and regulations are that are going to affect them, what would your recommendation be for them to really stay on top of things? Is there a place that they can go to really kind of like classify these things and really easily follow along? What would be the best person who may not have a legal background and understanding of a lot of this stuff to really stay up to date so they're giving the correct advice to their future collegiate student athletes?
Yeah, well, I'll make a little shameless plug here. I have a
Yeah.
website, collegesportslitigationtracker.com, that really looks to classify all the different lawsuits. I don't have all of them, because some of the state lawsuits are a lot harder to track. California, for example, wants to charge me, I think, $5 a page for legal documents, and I don't have that kind of money, and Boise State's not giving me that kind of money.
Yeah.
But yeah, I like to think my website's a really good resource for that kind of thing, to kind of keep track of these lawsuits, and especially for for recruiting advisors, and especially for people who are helping college athletes. the number one question right now is eligibility. And
Yeah.
there are two cases to really follow in the eligibility space right now. Yes, there's 40 of them that have been filed, but two of them really stand out right now. Those are the Patterson case and the Pavia case. They're both looking to be class action lawsuits. They haven't been certified as class action lawsuits, but because they would be class action lawsuits, they would apply across all of Division One, which is different than what I was saying earlier, but they haven't been certified yet. And Patterson looks to challenge the 4 seasons in 5 years. It wants to go to 5 and 5. Pavia is challenging the JUCO rule that considers JUCO years as part of, as similar to Division One years again on this broader scale. So those are the two. Like if you were to just go on my website and look at those two cases, I think you'd be
Yeah.
better off than many others in your profession. But also I would strongly recommend being on Twitter, being on those kind of areas, because not just me, but people like Amanda Krestovich at Front Office Sports, and just Mitt Winter, who's an attorney who
Yeah.
also talks about college sports a lot. There's a lot of really good resources on social media that really provide really good background and really an easy to understand way of what's going on in these legal spaces that, if you look at it on your own, they can be really complicated.
Yeah, for sure. So Patterson and Pavia, if you have a direct interest in eligibility, Sam's going to continue to do an outstanding job, really kind of keeping all of us up to date on what major changes may happen with that. So,
Mhm.
and also on our end at Sports Recruits, if we notice any major eligibility changes, we'll be sure to try and update our resource center as well. But now we're just going to take a couple of minutes. We have a few questions that came in, and I'm going to take a stab at this first one here. We had someone write in and ask to give a brief explanation of when recruiting can begin for a high school freshman or sophomore softball athlete. So, particularly in softball, the date that you're going to have in mind is going to be September 1st, entering your junior year. That is when quote unquote recruiting can begin from a standpoint of when college coaches can communicate with the student athlete directly. Now, keep in mind, if you are a freshman or a sophomore, there is no rule or regulation stopping the student athlete from emailing the college coach and providing them with video or sharing their recruiting profile or sharing their schedule at a major upcoming tournament. So if you are someone who is interested in playing at the next level, Division 1 is the one division that currently has limitations on college coach communication on their end. If you are someone who's reaching out to a Division 2 or a Division 3 school, they do not have that same red tape and they would be able to freely respond to your emails and maybe even give you a phone call. I would say if you're a high school freshman, chances are those conversations aren't happening a whole lot because recruiting tends to happen a little bit later. But if you have anything to add in terms of when you would consider quote unquote recruiting beginning for someone who's at, I guess, freshman or sophomore year of high school.
Nope, I think you hit the nail on the head. I have nothing to add to
All right, perfect. All right,
that.
here's another one I think that's more so in your lane. So, with all the legislation and changes and perspective changes, a lot of it is discussed specifically at this Division One level. This particular person who's asking this question, they have a lot of student athletes who end up going to Division Two and Division Three types of programs. What is important to know? What can help these particular kids? And is there anything that's even notable for someone who is going more so down that path?
Yeah, so you hit the nail on the head, Christy. All these proposed changes, really everything that I'm focused on, for the most part, is absolutely pertains only to Division One. There's been one lawsuit that I've seen that's asking for kind of similar treatment in terms of JUCO years and extended eligibility for Division Two, but it got dismissed because, largely speaking, the field of law that where these rules are being challenged is based on economic analysis. It's based on the economic market that arguably the NCAA through kind of their joint rules are excluding athletes from. And the same kind of money isn't really a thing at Division Two and Division Three, which means two things. One, there's really no incentive to file these lawsuits in the first place. And two, it's going to be a lot harder to win an antitrust case because you can't show the same kind of economic market.
Yeah,
Um,
right.
but as these rules pertain to Division Two and Division Three, I would say there's two things to really keep in mind. One, there have been some cases where, like for example, Nizer Forquin with Wisconsin, he's a football player there. His lawsuit was actually based on my years in Division Two shouldn't count towards my years of Division One. So his case is still working through the system right now. He was able to get a preliminary injunction, but it was overturned by the appellate court strictly for procedural things, in fact, because the appellate court actually came, in their opinion was definitely not
Yeah.
closed to the idea that he could win this lawsuit in the future. He just didn't have enough evidence at the time. So that could be a change where maybe there's more of an incentive to go to Division two, Division three, because it would count towards Division one years. But that's a long way off, and
Right.
potentially could be cut off by federal legislation or just by a loss in that case.
Right.
And the second thing I'd say to that end is just keep in mind kind of that there's always some trickle down. If we do have if we do have 5 and 5, for example, or JUCO years not counting, for example, in Division one, then a
Yeah.
lot of athletes are going to be trickling down, from the Power Two to the rest of the Power Four
Mhm.
to the G5 to FCS, all the way down to Division two and Division three, because they're going to be looking for open spots, they're going to be looking for playing time. So it could make it more difficult for kids who are looking to kind of break into Division two, Division three level to get spots. But again, I don't think we're necessarily there yet, and
Right.
something to watch, but maybe in the further future.
So even anything that does regard Division two or Division three, it's more so under the guides of they're trying to eliminate those years towards your D1
Yes.
eligibility. So
Right.
we don't really necessarily have a ton that's going to change from someone who plans to be a 4-year D2 or D3 athlete. This really would be something that would potentially change someone who's trying to transfer up a level down the road.
Yeah, like I said, the only lawsuit that I've seen that was filed by someone looking for an extra year at Division three or at Division two, I should say, got kicked pretty quickly. So that's definitely not a thing. And Christy, for your follow-up question, yes, rev share is only Division one.
Yeah. Yeah. Division one at this point is the only one who is doing a revenue share deal with their student athletes, mainly
Mhm.
because Division one generates a ton of revenue compared to those lower level programs. So
Yeah, and I should even say only schools that have opted into the house settlement. There actually has to be an affirmative act by the school to opt into the settlement. So a
right.
lot of schools at the lower level of Division one did not opt in, so they are not able to share revenue with their athletes.
In addition to the Ivy League and the Patriot League, I would say are probably the two most notable conferences that we saw on our end where a lot of our student athletes have interest in. They also have opted out of the revenue share piece of
Correct.
student athletes.
Yeah, the Ivy League, not too surprising because
Yeah.
they're very much about the educational
Yes.
sports.
Right. Which as they should be. I think they've earned that right at this
Yeah,
point.
I think so.
Yeah. Well, Sam, this was awesome. I know I learned a whole lot. I know there's a ton of misinformation and a lot of challenges, especially for people who may not come from the background that you have. And I think you do a really great job of, I think, just trying to simplify it for those who are just looking to become a better resource for these future student athletes that we are going to see at the college ranks down the road. Maybe something that we can look at later on is if we do see any of these major changes, maybe we can potentially bring you back on so you can kind of clarify some things because it does sound like a lot of what we discussed today it will not be the same way a year from now or 3 years from now or whatever that timeline is. So
Yeah, that's definitely for sure. And in fact, December 15th is going to be an interesting day because that's the day of the preliminary injunction hearing in the Patterson case, which again is looking to
great.
it is challenging the 4 seasons and 5 years rule. So how that turns, I think, will set the stage for a lot of these lawsuits moving forward, and a lot of really maybe the way that the NCAA treats eligibility at the divisional level moving forward.
Yeah. Well, I would recommend everyone follow Sam on X. Turn your notifications on if this is something that you do have a specific interest in. We hope everyone feels a little bit more educated and comfortable providing support and information on these topics to their student athletes down the road. But Sam, thanks so much for providing this time. Hope you enjoy the rest of your fall semester. And we will make sure to share a recording of this to everyone who registered automatically sometime tomorrow. So be on the lookout for that. But thanks again so much, Sam. It was really great talking to you again.
Of course, my pleasure. And yeah, for anyone out there, please feel free, not only follow me on social media, but feel free to email me. My email address is public. I'm an academic. It's pretty easy to find my email address. If you have any questions, I can't give legal advice, obviously, but if you have general questions about the landscape, I'd be happy to answer them more.
That's really valuable. Thank you so much, Sam. Thank you, everyone, for joining, and we definitely hope to see you again sometime soon.
My pleasure.